Welcome to Dolly Talk. How is everybody doing? We have another fun episode full of Timothy Olson antics. He is a pro se defendant accused of kidnapping a 79-year-old woman, as one does, and is on trial and defending himself. He's not a sovereign citizen, but he certainly is trying to delay things in the courtroom. So we are going to start with Cross of the lead detective, where his antics are starting to go into overdrive. Him and the judge don't see things eye to eye necessarily. Hey, Jackie, how are you doing? Oh, I'm sorry, Idaho Mom. I hope you feel better. Get plenty of rest. Hey, Maddie. Johnny's here. Tracy. Yeah, glad you're here too. Ella should be here in a little bit. So we will go ahead and start though. Maybe.
Thank you. I have no further questions.
Okay, Cross.
Okay, so when you interviewed Mr. Olson, what was it?
Not in evidence.
What?
Sustain. Okay, next question.
It's not in evidence? Okay, so did Mr. Olson deny knowing Miss Hannell to you when you spoke to him?
Objection, not in evidence.
Sustain.
Why isn't this in evidence? What?
Mm-hmm.
What is it when I tell you this story?
Go on, sweetie. You can do it.
Okay, so
Come on.
that just threw me off for a second.
Don't tell everyone that.
So how many stops did Mr. Olson and Ms. Hannell make while they were together? Not an abduction. They were together. How many stops did they make?
I don't know.
So how many stops were there made with the credit card? That you didn't. There was two that you said. One was Walgreens, one was SK Petro. What were the others?
Are you asking for credit card use?
Yes, because it's
I'm going to interrupt you for a minute. Mr. Olson, try not to ask one question right after another.
okay.
Ask one question, allow the witness to answer, and then ask your second question or following question, but don't ask them all at once.
Okay, I apologize. So how many other? If what I'm asking for is the names of the places other than Walgreens and SK Petro that you have proof of the credit card use during that time.
There was one usage at a Pilot gas station in Oak Creek. Another one in Milwaukee. I believe it's a Clark gas station. And another usage in Greendale, and I cannot remember the gas station.
Okay, so were you aware of the time frames that were spent there? As far as we'll use the Clark gas station, and this is on the south side. Are you aware of the time spent at these locations?
No, I'm not.
Very handsome.
Okay. Did you get any video from any of these other locations?
No, I did not.
So are you aware that Mr. Olson went in by himself to these stores and for a good amount of time, and Betty was in the car alone?
Objection out of the knowledge of this witness.
Okay. Are you curious as to why Mr. Olson was in Walgreens for how long? How long was the video?
It was a couple minutes. I mean, we all watched it together.
It was more than a couple minutes. Earlier you said it was quite long. Now you're saying a couple minutes.
The video footage from Walgreens is quite long.
Okay. So how long was the footage that Mr. Olson and Ms. Hannell arrived and left in between that time?
For what location are you asking?
For Walgreens.
Approximately 5 minutes, 7 minutes. I'm not sure.
Okay, that's not correct. Mr. Olson was in that store.
Mr. Olson, don't argue with the witness. Ask her a question, allow the witness to answer, and then move on.
Okay. So are you curious as to why Ms. Hannell didn't call anyone, leave, flag anybody down while Mr. Olson was in Walgreens?
Objection asked for an opinion.
Okay, sustained.
Are you aware there's a police station almost kitty corner from that Walgreens in that area?
I am aware where District 6 is located. It's debatable if it's kitty corner.
It's pretty close. There's a lot of cars going
Mr.
in
Olson,
and out.
don't argue with the witness. Ask her question, please.
Okay, so SK Petro, are you curious at all as to why Betty Hannell didn't alert anybody, anything? I mean, Mr. Olson was in the store by himself. Again, she got the keys in the car. There was no scream for help or anything like that. Are you not curious as to why none of that happened?
Objection asked for an opinion.
Sustained.
Are you aware that Mr. Olson knew Betty Hannell?
I'm not aware of that.
Did Mr. Olson ever tell you that he knew her?
Objection, not in evidence.
Much worse than Lori.
Sustained.
Oh, come on.
Lori didn't do half bad, actually.
You kept talking about substances in bottles, and were there any actual controlled substances found in any bottles?
No.
Was there anything to substantiate that Ms. Hannell was forced to drink something that, I don't know, in any way would cause her any type of, I don't know, for her to sleep all night?
Can you ask the question again?
Was there anything found in any of the bottles that she claimed that she was forced to drink out of? Was there anything found? Alcohol, anything?
The liquid was only tested for controlled substances.
Okay, so no, there was nothing found.
Objection, argumentative.
Sustained.
So did you take pictures of the inside of the car?
Yes.
So as I'm looking now, and I'd like to remind you that you're under oath, I received some paper copies of photos of everything that was found in Betty's car. Now, this new version of this phone now, of the discovery, So just so you know, I've been given a couple of different.
Ask your question, Mr. Olson.
Well, I need him to understand. Well, so the first, okay. So you took the pictures in the car. There's a picture.
Hey, Junior.
I can't put this into a question solely. So is there? So I'd have to show you everything in this in the photo array that you supplied of everything that's inside the all the pictures that were of everything that was inside the car, inside the Toyota, inside the Honda. Sorry.
No question.
Yeah, I think
Just
he's
one
getting
second.
there. Yep.
Yeah, the car.
For the record, can defense indicate which exhibit number?
You know what? But it's not there. But there's one missing that because in the first download, in the first discovery I had, there was a picture of what was in the passenger side. Did you find it? No, it's missing now.
No.
It was in the paper. It's missing. Someone took it out. But I have. So let me put it this way. So there's pictures of things found on the seats, the front seats. What I'm at, my question is, when you inspected the inside of the passenger or of the driver's side car, the door, there's a slot inside the door handle. Did you, I'd like to remind you again, you're under oath. Did you take a picture and find anything inside that driver's side door that you took a picture of, a substance?
Can you ask the question again?
Did you take a picture of a substance found that was shown with a hand in a glove holding a reddish substance inside the driver's side of the car? Is a slot on the door?
No, not that I can remember. That doesn't sound right.
So there's a picture. There was one picture with in the.
Let's take a little bit of a break here. Members of the jury, plan for 5 minutes or less. I remind everyone this case is not concluded. Do not talk about the case and do not conduct your own research.
Somewhere.
We're outside the presence of the jury.
Who's on here?
To try to minimize protracting this and provide some directive or guidance so that this could be a little more efficient. Mr. Olson, if you have exhibits that you would like to use, the procedure is you follow the same procedure as the state. You have your exhibits numbered for defense. Excuse me, please use exhibit number starting at 500. Mark your exhibit and then show the state first.
At 500?
500. Show the state first before you present it to the witness. We're going to go off the record and give you the next several minutes to put together your exhibits, mark them properly. Mr. Clerk is now going to hand you exhibit stickers for that purpose. And then when we come back on the record, you can then proceed with your cross-examination and use of your exhibits.
Okay, real quick. So the problem I'm having, and I want to get this on the record, is that the original download that I was given that really doesn't work now at all from JV Bash in 2003, June 2023. There were pictures that were on here when he showed it to me, and he gave me physical
Okay, Ms. Olson,
documents.
I am going to stop you there because relative to any discovery disputes or issues, the court has already dealt with that. We're going to go off the record. You have, as was already indicated this morning, the record, you have access to a laptop. You also have printed information, documents for your use. And so we're going to go off the record and do what you will with the content and organization of exhibits you intend to use.
All right.
I'm going to let the witness step down and return to his seat, and then we'll come back on in about
What's
5 minutes.
happening?
Okay?
We just started with cross of the lead detective, and his antics are not going over well with the judge.
Hang on. Oh, he's crossing you.
Yep.
Ah, sweet. Hang on. Do I get to say hi first? Hello.
If he must. Hi.
Hello.
There we go.
Hi, everybody. Hello. Did you see a juror spoke or
Yeah, I
kind of
did.
blurted out some things that
Yeah,
were kind of not that great?
I didn't watch.
Well, she said not guilty was never an option. Yeah. She didn't talk to a PR expert beforehand.
I love it when jurors talk and they give the first appeal point right away.
I know.
So about that, unbiased jury pool,
Yeah.
didn't Corey also try to get the jury moved
Twice.
and was denied a week before trial?
Twice. Yeah, it wasn't the first time. She didn't try for a change of venue just on the last week. It was a second time.
Yeah, it was the second one.
Yeah.
Yeah. And the juror said it wasn't okay. That's
Oh dear me. Wow. Yeah, I've only watched the little clip from apparently she spoke on Good Morning America.
yeah.
This woman, but apparently she's also, I don't know if it's just her or there's another one that's gone on to Emily D. Baker.
Oh, really? Probably.
So,
Well,
which makes me wonder whether or not she might have also been an Emily D. Baker fan beforehand, which is a bit of a concern too. Yikes. But we'll see. I'll have a look into it today. That's all I know about it.
Yeah.
Thanks for Half Irish for letting me know. And hey, Jackie.
Oh, thanks for showing this. Oh, Jackie, thank you so much.
Jackie, so sweet.
You are awesome.
All right, sorry to interrupt. I only had a little bit of a look as I was like getting my daughter ready for school, and I was just like,
No worries.
oh dear. Thank you for your service, juror. Maybe you should have just like taken a bit more time to think about it when you came out and talked. But they get all excited about all the fame and the people asking, "Oh, we want to talk to you."
Oh yeah. I wonder if
Maybe
Lauren's
too
going to get her
much.
mitts into it.
Lauren will be like, Emily, I hate that Emily. Emily, she sucks. She sucks and she's got stupid hair.
Off the record. You need to put together exhibits that Mr. Olson wants to use during cross-examination of this witness or any other witness or that fact. But Mr. Olson, I do want to remind you and let you know that you have access to the exhibits that have been admitted into evidence. And we'll follow the same process. If there's an exhibit that's already been admitted and you want to use it, Mr. Clerk has them. You let us know, then the deputy will bring it over to you and to the witness. So there is that pile of exhibit, and then you have your own if you have other exhibits you want to use.
Okay, really quick, since she did hand over the exhibit, the phone download, I would also ask the clerk to order the DA to give me a copy of the entire phone download so that I can have it. Mr. Russell, he just testified that it wouldn't open unless she gave him. It would never open for me. This was exculpatory evidence and a clear Brady violation in the middle of trial. I still don't have the full download.
Okay, we've had many hearings on discovery challenges, and the court went so far as to order the state to put together a checklist of
That's nice of them.
discovery, along with, I don't know what number of sets, version, or not version, but how many sets we've gone through, that the state has gone through already, but on more than one occasion, the state has turned over and then returned over discovery. So at this point, no,
Sorry.
and that's now,
Sorry.
okay, that's your second violation. Pursuant to the rules of decorum, you are to be removed, but I understand late in the day, that was a lapse of your judgment, I let that one pass.
What she started to do also is if he violates the rules, she gives him a 15-minute timeout. And they stop everything. He goes back into the holding pen, and they wait exactly 15 minutes before he's brought out again.
What, the timer and a dunce hat?
Yeah, basically.
Sweet. How fun. Do they get to like
That's the
watch
second
him
violation.
in the
I'm
corner?
sorry?
Do they get to like watch him in the corner?
Oh, I wish. They should have a camera.
Damn.
Okay, so with respect to that file, specifically the cell right file that was provided, I don't recall what ultimately came of that. It's been raised before, and discovery disputes or issues were resolved a long time ago. And at one point, I ordered that the state put together a checklist, which the state did, and turned over discovery yet again. I don't know how many times. Again, I'm the second or third judge on this case. But I'll first start with Attorney Watzowski. With respect to the electronic file, what was the latest on that? Because I know a copy was provided yet again to defense. And the copies were provided before to previous counsels. And I stand by, and consistent with the court's guidance and direction, I believe A.D. Sadowski turned over yet again another copy to defense.
I have received a flash drive from the Sadowski. I inserted it into my computer earlier. It contains the same 15,086 pages of a PDF document that she uses. I believe it's 114. Exhibit 114.
How do you do his
When
eye?
I worked with the cell right,
Well, lots of things. He's certainly pissed off the guards in jail. Also,
yesterday?
it could have been his concussion when he bashed his head against the cell wall.
But it wasn't like that yesterday.
The black eye can take a few days, I think, to form.
Right.
It did with my mom when she had a concussion a couple weeks ago.
I'm sure he did not look like that yesterday.
No, he did have it was more minor on one eye, so it's come in much stronger.
It looks really, really bad.
And apparently concussions can last quite a while, by the way. Who knew?
I know, yeah, it can for a long time.
Yeah, I was surprised.
Is he testifying today?
I don't know if we'll get to it today.
Well, okay, we better. I just posted about him.
download on the computer back at my office. It loads very slowly, and if I had known there was a way to extract just this PDF part of it, and because it's easy to work with, it loads quickly, I would have done that, but I'm not that technically adept.
That makes sense.
Sure, so if I understood you correctly, you are able to open it. It just takes a while, it takes some time.
With the one I just received, open instantly.
All right,
I don't know why John Bolton is his standby counsel, but oh well.
1 person at a time, Mr. Olson, and I'm talking to Attorney Watzowski.
But this is a portion of the total Celebrite download, because there's no, I don't believe there are any pictures or videos or anything of that nature. And, but it does have the calls and the text and, so Mr. Olson has that, and he did get a chance to scroll through it briefly during the testimony of the last witness.
On January, there was some before they won't open.
I don't know, I should be going into anything beyond what I just received with the 15,000 page PDF document, but Mr. Olson is correct that what I've received and what I've given him in my discovery flash drives is very hard to open. And in fact, I couldn't open the Celebrite on my laptop. I can in my desktop in my office, and why one works and the other doesn't is beyond me.
So basically, the two discoveries that were given to me that I was supposed to use, because the one that was given to me before by Attorney Basham won't open, and everything's deleted out of it. The two that were given to us by A.D. Sadowski on December 4th of this past year, 2025, the phone download won't open. I'm not sure if everything else, it wouldn't work for me all in the jail. But on this computer, the phone download, the Celebrite, none of it will open. I've had no access to this, and it's the middle of almost the end of trial, and it's just been happening. This is why the case has been delayed this long, because I've never been able to get items that I need from 7 attorneys, and I still don't have the phone download, where I've always claimed that there are texts that exonerate me on there. Clear text would completely exonerate me. And
Just that from it. I'm looking at document 109, which is state's document regarding itemized discovery list that was filed back on July 31, 2025. And I think this is.
What happened?
Oh, I got to go to the next stream.
Oh, Jolene.
Is section I or subsection I.
I had a dream last night that you went on Jolene's stream and you were amazing.
Really?
Yeah. I don't know why I had that dream.
That's very odd, but thank you.
You're great.
Was I?
Yeah.
Was I drunk?
I hope not, because I'll be very disappointed in you.
Just kidding.
Cell phone download folder. The subsection of that subsection I is C, which is an executable file for Celebrite. But state is that
It's really loud now.
electronic copy
Loud?
of the Celebrite, the cell phone download.
Yes.
Okay. And that's what you had filed with the court, indicating that's been turned over.
Yes.
Okay. So now we're all on the same page. Do you follow, Mr. Olson?
So
No, this is not an invitation for you to ask questions. I've got a point that I'm going to get to. So I'm asking you, on July 31, 2025, the state filed, pursuant to a court order, that they itemize, in a sense, create a checklist of the discovery in their possession that they are to turn over to you. And in that list, the checklist of discovery of items includes the Celebrite cell phone download. And I'm asking you, are we on the same page? Is that correct?
I believe so.
Okay, let's stop there. All right. So now my question is directed to Attorney Wasilewski. I'm not talking about Exhibit 114. I'm talking about Item 8. And within Item 8 is the subsection I, and within I is C, which shows that there's an executable file for the download. Is that what you mean when you say that you could not open that file? Effectively, that executable file wasn't working, but what that would mean is that sub I, which contains the cell phone download, was not opening.
Yes, that
Okay.
that corresponds to what you see when you open item 8 on the flash drive as a folder, and when you open it, it has contents that includes the items listed as.
Well, there's a .exe, which tells me that it's an executable file, which means that in order to open that folder or something within that folder, you have to execute that file, and it'll run, and it'll open the program, whatever it is that you're trying to access. So my question that follows that is to the state, and state, I believe you indicated this to me in the past, but while it may take a long time to open the file, you have been able to initiate that executable file, which then opens the download, correct?
Yes. And when you open the folder labeled account package, it also gives instructions how to do that. And what I also heard Attorney Bajaleski say is that it wasn't opening on this laptop, but he was able to execute the file and open all of the files at his desktop back in his office. So I would ask that he would confirm that, but it appears that he has been able to open that as well.
Is that correct, counsel?
Yes.
Okay.
Your Honor, may I have a comment, please?
So this is, it sounds like at this time, this is, if what Mr. Olson says is correct.
What?
Isn't that polite of him to put his hand up in class?
He is very polite, and
Be nice. I don't know why are we being so mean to this man?
I don't know either. I mean, he is asking for permission, and
Really, we should cut him a break.
he should. He's misunderstood.
He is. Seriously, justice for him.
Absolutely.
Let's just go down that road for a minute. Then it would sound like to me that it's a user error more than anything. The state has turned over what they're supposed to. It's in this list.
Yeah,
And within this list, thankfully, it notes what's contained in it. That is the account package.ucae, which is within the account package folder. That sounds like that's where the instructions are.
Correct.
And then within that folder itself also is the executable file, which allows you to open. All right, Mr. Olson?
Yes, so I don't have a desktop in the jail. I only have access to laptops, and it will not. I've tried. Everyone in that works
Really? No desktops?
Rights for prisoners.
in law library, they've tried to open it for me. Attorney Wazalewski tried opening it up on the laptop here. It won't open. That's all I have. So I've complained and wrote letters to everyone you can think of about this discovery, all the way up to President Trump about my innocence in one of these texts. I've recently contacted the FBI to investigate
Okay, Mr.
phone
Olson,
download.
President Trump didn't get back to you, sir?
Yeah.
Wrote President Trump.
You what? Did he?
Wrote President Trump, yeah.
Oh, good for him. At least he's
in law
trying.
library, they've tried to open it for me. Attorney Wazalewski tried opening it up on the laptop here. It won't open. That's all I have. So I've complained and wrote letters to everyone you can think of about this discovery, all the way up to President Trump about my innocence in one of these texts. I've recently contacted the FBI.
Timothy has the discovery. He can't open the
Contacted
discovery.
FBI.
Where's Cash Patel? He's going to get the discovery for Timothy. The best discovery.
I think the FBI is going to have to jump in.
Right?
Yeah.
They'll get right on that, Tim, right after they finish investigating Epstein.
And Nancy Guthrie.
Oh, yeah. Absolutely. Number 3 on the list, buddy.
Number 3. Nancy Guthrie's top. And then aliens.
Yeah.
And then Epstein.
Yeah. So he's number 4 or 5.
Yeah, somewhere down there. Yeah.
You said he was writing letters to people, including President Trump and the FBI.
Right, just like general FBI or Cash himself?
Sound like general FBI.
Yeah. Remember, like, Dr. John is trying to get hold of the FBI as well.
Yeah, you better call Cash.
Yeah.
To investigate
Okay, so
phone
I'll
download.
stop you there just for a minute. It's 4:22. I'm going to need some more time to work through this on the record with the parties. So I'm going to bring the jury back in and release them for the day. The instruction to the jury will be that we'll start tomorrow at 8 and go on the record by 8:15, same as what we did today. Stern warning to you, Mr. Olson. I trust that you're reminded yet again of the court's rules of decorum, as well as the court's rule relative to your voicing of medical symptoms in front of the jury, that the possible consequences for violating the court's rules would result, including the consequences include you being removed from the courtroom, and that hopefully you won't engage in any dilatory actions to delay this trial. So tomorrow, I expect we'll go on the record right at 8:15. Okay, we're off the record until the jury comes in.
I have clear wounds to my head. Please.
Detective, you may return to the table.
And it's really funny because you can hear him talking with his standby counsel.
I know I tried. Wait. Is there anything?
Later in, really hear it. He gets really pissed at his standby counsel too. That's why I fired you.
That's why I fired you.
Yes, please bring them in.
Can you admit? So you know how you say that he's fired 7 attorneys? Has he actually fired them, or have they left on their own?
Well, he fired the last his standby counsel. He did fire.
All right.
Or he said he didn't want him anymore and then represent himself. And the judge was like, well, you'll be standby and you still have to work with him. And
Yeah.
he was
Because,
less.
like, it wasn't like a Sarah Boone situation where everyone thought that, like, she fired them, but actually they recused themselves.
I'm not sure.
Yeah. Now you have to go back and have a look at the docket.
Yeah.
Yeah. If you actually go back and look at Sarah Boone's docket, like, they all actually just quit.
Okay, we're back on the record in the presence of the jury. Members of the jury, it's now 4:24. And so we're close to that time when I'd like to release you for the day. What I'm going to do is I'm going to release you. I've instructed the detective to return to the, and my goal is to go on the record at 8:15. I remind everyone that this case has not concluded. Therefore, you may not talk about this case. Discovery item. In the past, I believe I've signed, as well as Judge Childs,
What's
signed an
his
order
name?
allowing.
Chow, please.
The I doubt it guy, who's he?
Oh, yeah.
He's got a name. Yeah.
Smith?
No,
No.
no.
Johnny
No,
Miller?
he's from a case. Like it's a
No, I know. I'm thinking of his name. Johnny D. Miller?
yeah, forget it.
The Dumpster Bros.
Dumpster Bros. Thank
Yeah.
you.
I was thinking of their actual name.
No, I just want to know if they're Dumpster Bros. Yep, that's it.
The father was convicted, but the son got acquitted. Father should be out or eligible for parole in a few years. I know that was such a great case. I love those guys.
They're pretty funny. Yeah, let me just check something for a second.
The son was acquitted. He seemed the more likely of the two to be convicted to me. The only reason the father was convicted is because the provocation. Because he kept saying, take your swing.
Take your swing.
And kept telling him to like take your swing so he could shoot him. And that really takes away your self-defense claim because you were provoking it.
Rid of this.
Now the son didn't do that, and the son just kind of backed up the father. So, but technically he had a deadly weapon with the bat.
Right.
And it was a travesty of justice that trial wasn't streamed. I was so angry.
Anyway, sorry, I just got rid of that ridiculous layout that you keep bringing up.
Because the son shot after the guy was falling down. I guess it'd be a jury question or a jury decision. It was kind of like he shot him and then the son started to shoot him. So it was kind of like all at once technically. But yeah, I mean, I see what you mean. The son was a little later. So at that point, it really wasn't necessary for him.
Okay, sorry, I got everyone distracted.
Mr. Olson to access computers so that he can do discovery. And from Mr. Olson's statement, I understand that that has always only been laptops. Is that correct, Mr. Olson?
Yes.
Okay.
Yes.
So just answer that question. That's all. All right. But Attorney Wasilewski, you have been able to open that file on a desktop, just not on a laptop.
Yes.
And if not on a laptop, is that because you didn't have the patience for it and then just shut it down, or because it may take a while?
Yeah, I just tried it now and it seemed to open, but when I opened subfiles, it didn't have much.
Okay. So can we go off the record and can I ask the attorneys to just see if you can open a file on your respective laptops? I already did. You did? Okay. So good. All right. Let's go off the record. Could you
Is it just me? Or does his attorney look really like John Bolton?
I don't know who John Bolton is. Oh, right.
This guy, the creepy mustachioed guy.
Who is he?
He's kind of a neocon, loves war kind of guy. He's kind of made fun of by everyone in politics.
Okay, I can see the
Yeah.
resemblance. Just when you make these obscure American references, I've got no idea what the fuck you're talking about. You say Bolton, I think about Michael Bolton.
I know. Yeah.
Yeah.
I see that and I think of
Could you try on Attorney Wessel's laptop?
Your Honor,
So I'm fine if,
no wonder Trump never got back.
as long as I'm in view, if Attorney Vasilevsky and Mr. Olson want to look at this, this is the flash drive that I made. There's other files on this now too, but like it is the exact copy that I gave to defense multiple times. So if they want to go through it, I'm happy to sit here in view of my state issued computer and let them click away on all of what's there.
lies.
Okay.
Oh, sweetie. Don't do that.
So what I want to make very clear is, one, ensuring that
Oh, that keyboard's going to be so sticky when you get it back, sweetie.
everything's turned over. I believe,
He's
based
making
upon the information I know, the filings with the court, the representations of the parties, that's been done, that's been satisfied. The issue really, as I understand it, is whether Mr. Olson has the knowledge to know enough to open it correctly so that it opens, which is why I said that it sounds to me that it's more of a user error or a user challenge than it is that discovery wasn't turned over, or that if discovery was turned over, that somehow that discovery was in such a way intentionally meant to be difficult or disruptive to the defense's ability to organize his defense. So what we're going to do at this point, given the state's offer, is to go off the record for the parties to use the state's laptop to go over that item in document, I forget which document that was filed on July 31, 2025, relative to the Celebrate download. Okay, Mr. Olson?
Real quick. Okay, so even no matter what, the full discovery was never given to me until December 4th of 2025, just 2 months before trial was supposed to start. And those won't open on the laptops. It has nothing to do with knowledge or my ability to open it.
Mr. Olson, I'm going to stop you there because we are way past that point. Okay, discovery disputes have been resolved, and that's why we're at trial. Because
No.
and my for the record, which is already stated, the state is using their laptop. You have a laptop at your table. It's not a situation where the state has a desktop and is accessing that file on a desktop.
Okay.
So it's not even a machine issue. It's not a file issue. It sounds like a user issue, which is why I'm going to go off the record and give you an opportunity, because the state has graciously accepted that for you, to use the state's laptop and open up that file. We're going to do that, and I'll check back on you in about 10 minutes. Hopefully that will be enough time.
I just want to really quick object.
We're off the record.
You have to let me object, Your Honor. You can't stop me from objecting.
Your Honor.
She can't stop me from objecting to what they're doing. It was clearly malicious.
Okay, we're back on the record outside the presence of the jury. It's now 4:43. A little over 10 minutes was given for the parties to use the state's laptop to open that file. How did it go, Attorney Wasilewski?
I opened the chats and the instant messages or some kind of messaging
on this version?
On the version that Ms. Sadowski provided, and Mr. Olson looked at it and is not satisfied with what he saw.
Well, I guess the question is just, is it accessible? And it is, right? You guys were able to open, hold on. You guys were able to open it, correct?
Not our version. The her version only. Now, our version won't open. Any of the versions we've had.
All right, so why don't you try defense's version as well?
We've already tried that. Sorry.
Okay, let me turn to the state. Was defense's version able to be open? Just use my version that's already open, which is the exact same version that was given to the. Yes, but the question is, was defense's version able to be open? We didn't try. Okay, let's go off the record and try that. We are off the record.
I did try.
I never gave him this.
Over here, you just tried.
You tried it in my computer, but you didn't try it in
Good.
Back to the bird.
The presence of the jury. That was about 3 minutes, because we were at, I believe we got off the record at about 4:45, and now it's 4:48. So 2 to 3 minutes. But in about 2 to 3 minutes, state was able to open Mr. Olson's copy of that file, electronic file. So as I stated before, this is not a situation whereby state withheld discovery. This is not a situation whereby the file was not accessible to defense. It sounds like to me that this, again, is a user issue, in part because standby counsel was able to open the file on a desktop, albeit he wasn't able to open it on a laptop. And then just now, moments ago, the state opened the file on her laptop, and that file that was opened was Mr. Olson's copy that was given to him during the course of turning over discovery. So
that was not my copy.
Hold on, Mr. Olson. That's a second violation. I'm not done talking and you spoke over me. Because the jury's not here, there's no point in removing you for 15 minutes. But I remind you that I'm keeping track of.
Ooh.
Oh dear. Okay, the issue is between the computer and the chair.
Yes.
Mm-hmm. Dear
And
me.
his
Oh, look, he's
little
pissed.
fingering.
Dear
So it
me.
starts to get really good now. He's very close to getting a timeout and a
He's-
judicial spanking. Oh. Oh.
Dear me.
The number of violations you commit. We are now
Boy, imagine being abducted by this guy and forced to talk to him all night.
Yeah, I reckon.
well into this trial, and
I love you.
per the court record, it is correct that Mr. Olson did raise this.
Sir, look at this.
We are now well into this trial, and per the court.
Sir, you are not Jim from The Office, okay? You don't break character and look at the camera.
Ooh. Okay. In his defense, I don't think he knows where the camera is.
No, he
well,
does. The judge said yesterday he was looking for it.
Really?
Yeah, when he
Ooh.
was having his spaz attack.
He's doing a Lauren.
Yep.
Checking himself out.
Record, it is correct that Mr. Olson did raise this issue quite some time ago, which is why we went through this and numerous hearings, and the court had ordered the state to turn over, not turn over. The state then had created that checklist pursuant to the court's order. At this time, I believe the approach will be for Mr. Olson to have some time to go over this file and prepare his exhibits for cross-examination, and that's how we'll proceed tomorrow. But at this time, that's all that this has really come out to be, which is just Mr. Olson being able to open the file. Okay, Mr. Olson, what do you want to say for the record?
Okay, so for the record, that was not a copy that was ever been given to me, the one that they just opened.
I'm sorry, use the microphone. Attorney Washington.
Ms. Sadowski used my copy of the discovery and successfully opened it. And what I can do is simply swap out for the copies I made for him so that he knows that he has a copy that works in Ms. Sadowski's computer. And
yes, and
I would have taken his copy and checked it in Ms. Sadowski's computer, but I didn't. So I will substitute it. So you will have this new one, Mr. Olson, is the copy that I have that works. And
okay, so now standby counsel is swapping it out, but it matters not, I don't think so at this point, whether it's your USB stick, Attorney Wasilewski, or Mr. Olson, because it's the same thing. It's the same copy. But thank you for doing that, Attorney Wasilewski. And
May I finish?
No.
Oh my God.
that's now the third time you've interrupted me.
Oh.
She's a selfish lover, sir.
Again, in moving forward, we've ended early today. Tomorrow we're going to start early, but for the remainder of the evening and tomorrow, Mr. Olson has a file that was just proved to be, that could be open and can be open. He'll be given that time to go over that file and prepare his exhibit in the same fashion the state has done for use during examination. Okay, Mr. Olson, last word, and we're going to end it here.
Okay, and I would appreciate if I didn't get interrupted and you let me finish. I have to get things on the record. Okay, so for 41 months, I have not had access to discovery. That it doesn't matter how or who.
Mr. Olson, I'm going to interrupt you. No, you need to stop. First of all, you have to recognize that I'm the judge, and the judge, doesn't matter if it's me or another judge, but the judge controls court decorum, manages that, as well as ensuring that the record is created. And I cannot do that part of my job if you believe that you get to dictate when we do things and what goes on the record. Okay, that's not your job.
Not have it your way.
That's first and foremost. So when I tell you that that's enough, I mean it. That's enough. Secondly, you don't get to argue with me. You may disagree with how I'm proceeding with the trial. You may disagree with my decision on how the trial shall proceed, but that doesn't mean that that's a motion that somehow you get to place your position on the record, because you see, you're not the judge. You and I are not judging this together relative to case procedure. So if I say tomorrow we're starting at 8:15, we're starting at 8:15, you don't get to tell me that instead of 8:15, you want to start at 8:30. If I told you that we're going to go off the record so that you can confer with standby counsel and with the state and ensure that that file can be open, that's not up for your feedback. That's the order of the court.
It's not a democracy.
I want to make sure that I point that out, because tomorrow we should not have this back and forth again. We've lost so much time. Yesterday we ended early. Today we ended early yet again.
and tomorrow is Friday. I'm going to gauge how things go in the morning, but I really, really would not like it if I have to tell the jurors to plan on coming in on Monday. When we did voir dire, I conveyed to the panel that I expect this case to conclude by the end of the week.
Uh-oh.
At the rate that we're going, that there's a high possibility that might not be the case. So there are a lot of things that I'm trying to manage. There are a lot of things that at this time is so fluid, and we have to be able to pivot. Again, you may not like my decision, but pursuant to the rules of decorum, as I reminded you many times, once I've made a decision, you can disagree with it, but you don't get to go back and forth with me on it.
Okay, so real quick, you said I can view this discovery. I have no way of viewing the discovery in the jail. You've placed me in the hole as punishment for having a seizure. I have no way.
Well, you've placed me in the hole as punishment for having a seizure.
Ooh. Okay, there's two things going on here, right? I agree with her in that he can't just interrupt her whenever he likes. I get why she's pissed about that. But on the other hand, he's saying he can't see the discovery now, and he hasn't been able to see it for 41 months. And he's just trying to review it. So I mean, I see his side as well in that regard. Why can't he see it properly?
I think he can. He's doing everything in his power to just delay things to be a pest. So he's saying all the buzzwords.
Yes and no, right? So if the discovery is only viewable on a desktop computer, and he's only been able to see it now in court, like he'd properly review it now in court, then that's a bit of a problem, right? Because he's pro se, and in jail or prison, you don't have access to the same equipment that you would have in a courtroom.
Although, yeah, you do have access to your discovery, although there are going to be disadvantages to being pro se, and that is accepted.
Well, that's a big disadvantage, not being able to go through your discovery properly.
Well, no, yeah. But, he's in court on his laptop now, so.
Yeah. Yes, I know, but that's now, and there's a lot of discovery.
Yeah.
And he's actually trying to run his case at the same time as, like, looking through the whole file.
Yeah, so but it also gives him ways to delay.
Yeah. See, moments in trading hears me. Right? So, I mean, yeah, he wants delays. Why is she giving in? So I get it that he shouldn't be interrupting, he shouldn't be rude and all that kind of stuff. But also, I feel like, and we had this with the Sarah Boone trial, there should be a way for pro se defendants to have proper access to their discovery, including access with like a room with computers and phones and everything that they need to properly view their discovery.
But
because I feel that they don't get it.
Have people like this who are just using any opportunity to delay and delay and delay.
It will be taken advantage of. I get that too. Yeah, I get that too. That criminals will be criminals too.
No one's gonna come. I don't have a laptop in my cell. I have no way of viewing this right now before tomorrow. This problem should have been solved a while ago. But whatever. However, I'm just letting you know. So I don't know what else to say as far as that goes. But I also need to complete this motion for a mistrial, which there are numerous reasons for a mistrial, and I would like you to ask Attorney Wazalewski to come visit me tonight at the jail and help me complete this motion, because again, I have no access to anything to complete a motion. Case laws, nothing. Usually I have a tablet in a cell with case laws.
Can you make my lawyer that I fired, my standby counsel, visit me in jail tonight?
And stuff. But I'm gonna need his help tonight, and I would just ask him. I don't want him to be ordered. I just really need him to help me with this motion. He is standby and he should help me. Sorry, I really need his help, his experience with this, and I would really appreciate that.
Attorney Wazalewski is standby counsel. He doesn't represent you. And to that end, he cannot be drafting, unless the court allows him to do so, to be drafting motions for you. Hold on.
I was going to draft it.
To the extent that there can be information imparted to assist you, he may do so, and he knows that. I'm not going to order standby counsel to work hours that are not manageable. That I view that as beyond my authority, and I'm not going to do that. If Attorney Wazalewski wants to do it, and he can decide that, but I'm not ordering him to do something that imposes on his personal life as well. So that's all I'm going to say about that. But with respect to your access to resource, I do see that Judge Child had signed that order to allow you access, and I thought I'd signed one as well more recently. And if I didn't, you at least have Judge Child's order to give you that access. Now, my ability to order that the sheriff
He's going all night chat.
give you specific access, that's beyond my control. I don't control the library hours. I don't control what resource they have and that they must give that to you. But I have ordered, or at least the court, whether it's myself or Judge Childs, have ordered that you be able to view digital discovery. I'm sorry, I just don't know what is available to you. Deputies, are you guys aware? Okay.
All right. Well, so it's 4 days into trial, and I'm still not able to view any of this. So I just want to get that on the record. It's clearly a violation of my rights. I believe I had one more quick question, but I just can't remember what I was going to say. So let me see what. Oh yes, I would like to ask that you order Detective Zalewski to turn over the original phone download that isn't redacted, tampered with by Denise Sadowski, because I seen text in the phone that exonerate me with my own eyes. So I know they exist. So if they did a phone download, they have to be in there. And it's very strange how there were unredacted phone downloads, surfacing and stipulations.
I want to see these texts.
And given the media, there's a lot of things that seem very, very shady going on around this phone download.
I'm going to stop you there because this is a repeat of discovery issues that have been discussed in the past. However, though, because you had a good deal of time on the record, I do want to give the state an opportunity to add anything to the record as well. State.
I asked Detective Zalewski if what I was looking at on my computer is exactly what they have at the police district, and he said yes. He actually got kind of annoyed with me, and I told him to calm down because he goes, I only turn over exactly what I have. So I think everyone's patience are being tried today, and I also don't appreciate when Your Honor's out of the room that Mr. Olson has been using some not so nice words for the detective and calling me names as well. So I'm just saying that I'm trying to be overly accommodating in this situation, and just
Detective Zalewski is the son of a bitch. I'm sure this dude isn't cool enough to make up a song.
No.
If he's cool enough to make up a song, then I'll give it to him. But I'm pretty sure he's not cool enough to make up a song.
No.
So fuck him.
Not even cool enough to wear a normal tie.
No. So like he hasn't got a cool suit or anything like that. So fuck him.
Yep.
again, I'm going to use your words again, Your Honor. Hopes and dreams and wishes is what Mr. Olson is pinning this on, and it's just not there. And if he saw it with his own eyes, how did he see that if he couldn't open the discovery?
Right.
Okay. Mr. Olson, perhaps I think going forward, what I'll simply do is just remain in the courtroom because only I can make a finding of a violation of the rules of decorum. And so because I left, although of course, just because I wasn't here doesn't necessarily preclude me from making a finding that you violated the rules based upon what's represented to the court. But I remind you that under the rules of decorum, you must be respectful of all times. And also that under the rules of decorum, you must accept and respect court rulings. And a lot of times today, you did not accept or respect court rulings. But I'm reminding you yet again, so that tomorrow we should not have these challenges or issues. Okay, we're done for today. We're well past 5 o'clock now, and tomorrow we'll start at 8 o'clock and go on the record 8:15.
I got it already.
In person, in street clothes, pro se, Attorney John Wasilewski appears as standby counsel.
Good morning to everyone.
Even his first
Of
name
note
is John?
is that one, we're outside the presence of the jury. It's now 8:22. As everyone recalls, I had ordered us to go on the record 8:15 with the jury, so we're running a little behind. Of note is that yesterday I did try to make arrangements with the jail lieutenants and Director Briggs to ensure that Mr. Olson is given access to the law library to use any computer or laptop that is customarily provided to inmates. And I understand that that was done. And I was also informed that when the Deputy Bruce, that is, went to meet Mr. Olson at 7:15, he was already in the library. Director Briggs did inform me that as soon as they're able to, which would be after roll call, they would take Mr. Olson to the library, and that would be about a little after 6. And so when Deputy Bruce went downstairs, that was 7:15. Mr. Olson was already in the library, and then he was brought up at 8:05. So that was the time that he was in the library. In addition to that, I do want to, as exhibits are being used more frequently, I just want to remind everyone, parties and others, that if anything is needed during examinations, such as a microphone, you are to obtain permission of the court, and at no time should anyone enter the witness box or approach the witness without permission of the court. Okay, reminding everyone. Okay, now we're going to continue at this time. Mr. Olson?
Yes. So those parts of the discovery and numerous others don't open. There's one or two missing from one of the drives. Again, the drive that I initially had from 2023, which is completely had been messed with by somebody. There's something wrong with that. That one never opened, and I've always complained about that. The two that I had, he tried opening here, it wouldn't open. The one that would open wasn't mine, and that was open on Ms. Sadowski's laptop. The laptops in the jail are much different. These two drives, again, so I have never had full access to discovery. Never. Very partial. None of the police reports will open. None of the downloads will open. Some of the photos from the.
And I'm going to interrupt you. And one thing I do want to make. No. You don't get to tell the court to hold on. But this brings me to the point I want to make. And I think hopefully I'm answering your question because you seem to challenge the court's authority to control the proceeding. And I'm just going to remind you again that the reason why I do in fact control the proceeding is because that's my job. I have to move this case along. But specifically in a situation like this where my instruction previously, and again today, is that with respect to discovery issues, I'm hearing a lot of what's already been hashed out or discussed previously. I know that you don't feel that way, and that's perfectly fine. But the fact remains that the court has made its decision. We are well past that stage. If this is another motion you'd like to bring, then do so. But what I'm trying to prevent is for us to relive history and create another 5-10 pages of a transcript. Okay? I'm not denying you an ability to raise those issues with the court. I'm simply telling you that we need to be more efficient. We've lost a lot of time, and that you can do this by way of a written motion so that you can make it very clear and be particular and specific as to what you believe is the issue here. I've heard a lot of this before, and as I explained yesterday, the court went so far as to issue an order to the state to itemize the discovery, turn it over yet again, and I don't recall off the top of my head the number of times that discovery has been turned over. The state has turned over discovery more than once to more than one attorney and more than once to you, as well as the court itself turning over an extra copy of a USB drive to you. So I don't want to belabor the record anymore. And I'm giving you another opportunity to simply articulate with specificity in written form so that I can properly address that, but also so that the state has a fair chance to respond to your motions. Okay,
hold on. I have the motion. I have the motion right here.
No.
I object. You have to allow me to submit the motion. No, you're violating Wisconsin Supreme Court rules.
Violation number 1.
That's okay. I have to submit my motion, and I'm declaring a mistrial.
Stop talking. That was your first violation. Your second violation will result in your removal for 15 minutes. And let me remind you, as well as everyone else, that this trial has been delayed, and it will be if you continue to act in that way. Okay.
If you keep delaying this trial, I'm going to give you what you want and delay it for 15 more minutes, young man. So buckle up, buckaroo.
Is anyone else more annoyed with her than him?
Yeah, I mean,
she's really pissing me off.
Like, if somebody wants it, it's kind of like my dad who got suspended for not going to school. And then he had to serve detention to come back to school. So he took another 2 weeks off. And it just gives him what he wants.
Oh, you have to have counsel and know how to do this because you've done this many times before.
She's giving me Judge Doro vibes, like, Judge Mummy. Like, and it's just because she has to. I get it. Like, I know she has to put all this shit on the record, and because he keeps interrupting her, she keeps having to say all the stuff out loud. It's Wisconsin rules. That's how it works, right? So, and because he is acting like a naughty child, she has to sound like his mom, basically. And sorry, because she's a female, so I have to say the mom thing. But if it was a male, it would be a dad thing. Yeah. But it continues, and it's like a
MILF thing.
No, it's not like a MILF thing. Don't be like that. Gross. You creepy man. You creepy man.
Oh, MILF thing as well. Happy.
But it's coming off just like she's having to scold him, and it's getting really fucking annoying. Her voice is pissing me off.
Yeah, she doesn't know how to deal with him. She's had to go back a couple times and call somebody to figure out what to do.
Oh, I think, I don't know if she doesn't know how to deal with him. She has to, she's doing what she has to do. She's reading it all out on the record, how she's dealing with him, just like Judge Doro did with Darryl Brooks. It's just super annoying to have to listen to, because that's how it works in Wisconsin. You got to speak it all out on the record.
Just imagine if this was Judge Borowski. It could have been.
That would have been actually great. Imagine.
That would have been, oh my God.
Yeah,
That would have been the greatest trial ever.
it would have been.
Have a written motion, give it to the clerk, he'll upload it to the file, and thus it will be deemed filed, okay? But same process and procedure as before. Don't approach the clerk, don't approach the court. The deputies are here. Hand it over to Attorney Wasilewski. He can then indicate it to the deputies, come pick it up, or the deputies can come to you directly and take your motion and then give it to Mr. Clerk to file. That's it. That's all. There's nothing else we need to say on the record.
Yes, there is. There's lots.
Violation number 2, remove Mr. Olson for 15 minutes. It's 8:28. We'll be off the record for
I'm
15
out,
minutes.
young man.
Can you give that to the clerk?
Stand up.
It's not a punishment.
No. Sorry, I have to.
You need to start sticking up for me, John. Yes, that's the entire motion right there to the right.
You got to start sticking up for me, John.
It's so stupid.
You fired him, you get. And now he wants him to give the motion to the judge.
This is so silly.
Your Honor, while Mr. Olson is being escorted from the courtroom, he has indicated that there is a stack of papers on the defense table closest to you, and the entirety of that, he tells me, is his motion. With your permission, I'll walk it to the clerk.
How many pages do you know?
I don't. I haven't viewed it.
You want to give me a rough estimate after you take a look at it?
I don't know. I don't care.
It's interesting, Elros. Like, he wouldn't even try half of this shit if the judge was a
You guys
man.
would just
It's
let it go?
disgusting. Well, I'm not sure about
70 to 80.
if it was just a man, but if it was Judge Borowski, like a man like Judge Borowski,
Yeah.
hell no. Right? Did you see us stream the sentencing with Judge
Yeah.
Borowski and that teenager who stabbed another teenager?
For sure.
My God. No one was
Yeah.
getting a word in. Like, he would scare the pants off
Borowski
anyone.
once held a public defender in contempt, and he did feel a little bit bad because he didn't realize when he did that meant that the public defender would be shackled and put in a jail uniform. So he came back out later to deal with the situation. He comes out all shackled. Yeah, he doesn't mess around.
Scary dude.
Pages.
Scary dude.
Only the first
I just wish MLS knew him.
Hey, Tracy.
7 pages appear to be the motion per se. I assume the rest of this is what he would characterize as exhibits or supporting documents.
What he
Okay.
characterize as. I love that. Yeah, it's not what it is. It's what he would characterize it as.
Before we actually have Mr. Clerk scan it into the system, when Mr. Olson is brought back, I want to confirm with him that is in fact all of it, because I want to avoid having to do a second or third scan. And so we'll have him confirm that in fact that's all of it. But it's good to know that he has it all ready to go.
Yes, or as this is just a suggestion, take it or leave it. The clerk could scan it now, but not file it until, and maybe even scan it in parts. I don't know.
Well, I don't think the system's that savvy where he can just add to the same scan. I don't want to have, for example, document 20 created and then we have to create document 22. It should just be one document, one scan of the entire motion. I don't want anything to get lost in the filing.
Okay, well,
So we'll just leave it.
however the court directs is fine with me, but I usually file a motion, and then if I have an attachment, I file it as a separate document, but that's just me. I don't know if that's
That is true. That is just you. This is Mr. Olson.
going to advise them of anything or say nothing, or the jury coming in and seeing an empty chair at Mr. Olson's place. Are we going to advise them of anything or say nothing, or?
We're not bringing in the jury just yet. We're waiting 15 minutes. Time out. Yeah, it's time out.
Okay.
Yeah.
I was concerned that
Because after 15 minutes, I still want to confirm he can follow the rules. And then talk about the motion, the number of pages. I don't want any allegations that the motion isn't complete, that somehow pages were lost. That's not what he intended to file, so on and so forth.
So yeah, the entire
there are a
court-
couple of housekeeping matters we could address if the court wishes. I don't know, maybe the court wants to wait till Mr. Olson's here. I don't know.
Yeah, let's wait till Mr. Olson is back.
like at least his standby counsel is at least trying to keep the freaking trial moving. But she's just like, nope, he's in timeout. I'm just going to sit here for 15 minutes. Don't make me turn this trial around. One more word out of you, and no more McDonald's, young man. Yeah, they just sit there for a while.
Phrase it to me as red, crumbly something, but
They just all sit there for 15 freaking minutes. It doesn't seem like all that much of a punishment for him. My God.
Why? I want you to make sure that, in fact, that stack of papers is everything that you want to file as part of your motion. Once you confirm that, then the deputy can give that to Mr. Clerk and we'll scan it in. Is that correct?
Yes, I just want to make sure that I'm putting it on the record that I'm filing a motion and demand for mistrial and dismissal based on extreme constitutional violations, jury tampering, jury poisoning, misconduct in office, abuse of power, miscarriage of justice, obstruction of justice, violation of my due process. I have no discovery. Your deputies, I want to ask that you confiscate your deputies' phones because they're texting and talking about my case in the back, and they've been doing this for a couple of days. And I've also noticed the jurors doing it in the hallway, talking about getting Facebook notifications. There's probably close to 6 or maybe 8 now that I've inquired in the hallways as I've been being brought through the hallways every day ever since Tuesday, since before I was even getting these clothes put on. They're all...
save the detail for your motion. I've understand. Haven't heard what you just said. I have a general understanding of the general basis. I don't need the details because it should be contained in the written motion. Okay. And that stack of paper, is that everything?
Yes.
Okay. So then, Mr. Clerk, deputy, if you could take that and present it to Mr. Clerk.
Sorry.
The clerk will scan it in, and once it's scanned in, the legal parties, but specifically the state, should have access to that. You might need to refresh state once the CCAP entry is pulled in, and the state obviously has an opportunity to respond, and so that means that time will be given for the state to read the motion. I understand it is quite lengthy, and that was a big stack of paper.
Real quick, Your Honor, I just want to state that the only thing that's missing out of there is case laws, and that's because I was stripped of my ability to look at any case laws now in the place where I'm being housed in the jail, so I have no access to that.
Okay. State, anything you want to place on the record at this time? I haven't read the motion, but I think that Mr. Olson, by his antics a couple days ago in his wheelchair in Orange, I think the cat's out of the bag that he was in custody. So any jurors that are seeing him is kind of a moot point. That's the only response that I have right now, because as Your Honor has already noted, we've turned over discovery probably each time to a different attorney, a copy directly to Mr. Olson. And frankly, when you're pro se, some of the case law that I cited earlier this week, it's the defendant's own peril when you proceed pro se if these things don't go as smoothly as you would like. So, that's all I have to say. But again, I haven't read the motion, so I don't know what else to respond to at this time. Okay, no, that's all. No, that's all. No, you can't, because I'm not hearing the motion right now. No. Okay, so my plan this morning is, at a minimum, complete examination of state's witness, the detective, and at that point we'll take a break. I'll inquire with the state as to witness lineup. I think it depends on when the parties.
I'm just going to skip this part.
From the car. Do you have possession of all of the photos that were taken from the car? Yes, the original, not the what the DA has, but the originals that you have. Yes. Would you mind turning over all of those photos to defense?
Grumpy old man.
Because I believe there's one missing from what I originally got and what I was now shown by Attorney Wesley.
You cannot testify through your question.
Okay.
Just ask your question, okay?
Would you mind then, is there any problem to give defense everything that you have from photos from the white Honda belonging to Benny Hamill?
What is your question?
Can you turn over all the photos to defense, directly to defense?
All photos and evidence?
All photos from the, taken from anything found in the car and the inside of the Toyota, of the Honda Accord.
All evidence collected, all photos, gets turned over to the state, to the district attorney's office, which then a copy gets made and is given to the defense for discovery.
Okay. Can you turn over all those copies directly to defense? Would you have a problem with that? Is there any problem with that? If there...
Objection, relevant. Okay, sustained. Move on, please. Next question.
Objection, obnoxious.
So I would like all photos turned over from the car.
Objection asked and answered. Sustained. Next question, please.
Okay. During your investigation, isn't it true that you found out that Mr. Olson actually knew Mr. Schuster?
You're back.
No, not that I'm aware of.
Isn't it true that you found out that Mr. Olson actually may have had permission to be in the RV, which is, go ahead, I'll let you answer that.
No, Mr. Schuster testified that you didn't have permission.
That's not what I asked. Isn't it true that you found that out, that it's possible that Mr. Olson actually had permission to be in the RV?
No.
Isn't it true that this is why Mr. Olson was in that area for several days, because Mr. Olson actually had permission to stay in the RV?
Objection. He's testifying again, Your Honor. Okay, sustained.
No. So you did testify that Mr. Olson was in the area for several days. Isn't that correct?
I don't know if I testified to that.
Did you find that out throughout your investigation?
Yes.
So where was Mr. Olson staying during those days in the area?
Objection, Your Honor. The witness should only testify if he knows the answer, not speculate. I think Mr. Olson is calling for speculation.
No, I'm asking.
Overruled. Overruled. Answer the question if you know the answer.
I do not know the answer.
This is so painful.
Are you the person that completed the phone download of Betty Hamill's phone?
Yes.
And you had testified yesterday that items cannot be removed from that phone download. Isn't that actually false? Items can be redacted, unredacted, and so forth.
No.
Items can't be redacted from the phone download. Is that what you're saying?
This depends on what your definition of redacted is.
Redacted is a pretty common word, and there's one definition for redacted. It can be removed.
Sorry, Tracy. Darley's
Removed
dishes.
from the phone download is pretty common. There's an unredacted version. And
Question, Mr. Olson?
so your testimony yesterday isn't exactly quite true, is it, about items being able to be removed from the phone download?
Items are not removed from the phone download.
So the version that is given to the DA, you're telling me that the DA cannot at all remove items. It is not physically possible?
Correct.
That is incorrect. That is that. So is there not an ability on the computer to remove an item from the phone, from the download that you give her on a flash drive? She's able to delete that item if she chooses to, correct? I'm asking.
If you have a question, ask the question, allow the witness to answer before moving on to the next question, and do not testify through your form of question.
I can't. Sorry, Tracy.
Oh, okay.
Sorry.
Members of the jury, let's take a break. Plan for 5 minutes or less, and then we'll come back. I remind everyone this case is not concluded. Do not talk about this case. Do not do your own research. Do not post about your experience and what you've seen or heard so far. Thank you.
It's all like phone download said you can do that, unredact, remove. It's on the Celebrate program.
Great. We're outside the presence of the jury. Mr. Olson, I believe I said this. Yes, I did, because it's in the rules of decorum. Okay, during examination, keep scope of examination relevant. On direct, no leading questions. Do not harass, intimidate, or argue with the witness. And of course, the last point there, these are not an exhaustive list of things to do or not to do during examination, but it ends with do not speak over one another. Do not harass, intimidate, or argue with the witness. You ask your question and you move on. If credibility is what you're getting to, there are ways to do that, but you don't argue with the witness and you don't harass them. Okay? And I have said this to you a couple of times, so I'm going to remind you yet again that it's impermissible for you to testify through by way of your form of question. You cannot do that. And when you do that, the state will object, which they've done, and I will sustain that.
Okay.
I want to make sure that we're on the same page. Are we on the same page?
What's that?
Thanks, Sally. You've left us with these insufferable people who we can't pause and we can't understand, and you dished us.
I had to use the little girl's room.
Yeah.
I'll
And
turn
Tracy
down
would
the
like
speed.
captions on it. Is there any captions on this one?
Unfortunately, not on this one.
Right.
Yeah, YouTube was asshole.
Yeah, it's probably because there's this section in the middle of it here where they're just like really muffled.
Yeah.
Yes, and I did not mean to do that. It's just I'm not familiar with the process of answering or asking questions.
Sure. And that's understandable, which is why we took this break, for me to remind you. And I also want to remind you that there are a lot of things you're not going to like about this whole process, including, of course, not liking my decisions, but also including not liking the answers from the witnesses. It's their answer. You don't argue with them. You ask your next question and you move on. Is that clear?
Yes, Your Honor.
Okay. So let's bring in the jury and we'll continue.
May I ask one quick question?
Yes.
When Mr. Olson testifies again, I don't know at what point it's appropriate for me to object and cut him off, because decorum would say at the end. So
I think for clarity of the record and for the record to be complete, I'm just going to say, do what you need to do.
thank you.
And let's just move on from there.
I just don't want to violate the rules.
That's understood. Yeah.
I don't want to violate the rules, Your Honor. And he just goes, oh my God.
That's understood. Yeah.
Suck up.
We're off the record until the jury's brought in. Do you guys have to duty judges? We don't duty judge today, so if there are any warrants that come in, just have them wait.
Just like,
Okay, Isn't it true you can generate reports from the phone download and exclude some and include others into what you're giving the state?
Can you repeat your question?
Isn't it true you can generate reports from the phone download and you can include or exclude things to the state?
Objection, Your Honor. Compound question.
Overruled. You may answer the question if you know it.
When you're generating a report, you can exclude data such as dates or time frames, but that would then include that through the entire phone download.
Do you have a copy of the original phone download conducted from Betty Handel's phone?
Yes, and that's what was provided to the state.
So, are you aware of, let me rephrase this. So through your investigations, you did find that there was a text from Betty Handel to Mr. Olson, isn't that correct?
No, that's incorrect.
So through your investigations, you found a text that was to a number that stated, "Where are you? Are you coming back?" during the supposed alleged abduction.
No.
Isn't it true that you found a text that stated, "You didn't tell Rex that we knew each other, did you?"
Objection, testifying.
Sustained.
Isn't it true that you found a text during this also alleged abduction stating, "My credit card has a $25,000 limit"?
Objection, testifying.
Sustained.
Wow.
So through your conversations with Mr. Olson, isn't it true that Mr. Olson stated that he knew Betty Handel?
Objection, hearsay.
Overruled. You may answer the question.
Yes, Mr. Olson said he knew Betty Handel.
Isn't it also true that when you inquired to Mr. Olson about this alleged incident, that Mr. Olson had told you to check Betty's
Objection,
phones?
testifying, and hearsay.
Sustained.
Isn't it true that Mr. Olson directed you to Betty's texts ever?
Objection, hearsay.
Overruled. You may answer the question if you know it.
Can you repeat the question?
Isn't it true that Mr. Olson directed you to check Betty's texts for anything pertaining to this incident?
Yes.
Do you still have the iPhone in your possession?
No.
Does Betty still have the iPhone?
I don't know.
Uh-oh.
So,
Got him now.
because this is material to the case and very important, would you have any problem turning over the original phone download conducted by yourself to defense in the court right now? So that I'll let you answer that.
The original phone download was turned over to ADA Sadowski when the case was filed.
Okay. Isn't it true that yesterday you told Mr. Olson in the courtroom, off the record, that you have the original version in your possession?
Objection, hearsay, and relevance.
Sustained.
Oh, Vince. So, and again, because it's so important, would you have any problem turning over the phone download, the original one that you have in your possession,
This is so great.
would you have a problem turning that over to the defense and court so that it can be examined by a private investigator and also the FBI?
Mr. Olson, I think I already answered this question.
No.
The phone download that was conducted of Betty Handel's phone, the original copy was given to the DA, and then you're provided with a copy. So everyone has the same copy.
So do you have the original phone download in your possession?
Okay. Mr. Olson, I'm going to direct you to move forward. You are badgering the witness.
No,
Next question, please.
He's not answered it. Would you mind turning over the original download to the defense?
To the jury, we're going to take a break, and I'll have you brought back in about 5 minutes. Okay, remind you, this case is not concluded. Do not talk about this case. Do not conduct your own research, and do not post about your experience.
You didn't answer that. It's a yes or no question.
It's a yes or no question. I don't know what I'm doing wrong.
Last one, please, open the door. Thank you.
Say yes or no. You have to say yes or no.
Okay, we're outside the presence of the jury. Mr. Olson, I'm reminding you again that pursuant to the court's rules of decorum, paragraph 13, and again, this is not an exhaustive list, but during examination, do not harass, intimidate, or argue with the witness. You've been instructed to move on. You then proceeded to nonetheless ask that same question, maybe slightly differently, but same question. And I really should be counting this as your third violation and removing you from the courtroom and allowing you to then view this trial by Zoom. And as you may recall, I specifically laid out the procedure that if you are removed from the trial and you can only view it by Zoom, you may provide to Attorney Wasilewski specific questions that you bring that you want him to ask. Because I already gave you notice, I can count this as a third violation. But I don't know that you fully appreciate how serious I was about ensuring that you understand the rules of decorum, that you follow it. I'm going to ask you one question. Depending on your answer, I'll know how to proceed. Will you follow the court's rules of decorum, including the rules related to examination?
Well, I'm objecting that, Your Honor. I'm not purposely violating any rule.
I'm sorry?
I don't think he knows what the word decorum means.
No.
He should probably be like instructed, like given a dictionary.
It might help.
Decorum.
Then again, he needs help.
I'm trying to get the
Ending in just a minute, guys.
Yep.
We'll start tomorrow at 5, so an hour earlier. I
Yep.
think we'll get into him testifying tomorrow.
Yep.
And it's a dumpster
question out, and I felt that he never answered it. He never said yes or no. It was a yes or no question. You're allowing him to go around the question. And this is extremely important to my case. I've always claimed that there were texts and...
Mr. Olson, okay, I'm going to stop you there. I said this before, and I'll say it again. There may be a lot of times when you're not going to like the witness's answer, but you move on. Right? You don't get to direct how this trial proceeds, and that's what you're trying to do, because the procedures are quite clear. It's been laid out. And to the extent that you didn't think you were violating the rules of decorum, the second time I'm reminding you of these rules, which is why I'm being extremely patient and tolerant of your antics, okay? So much so that
What's wrong with my...
when I should be counting this as a third violation, removing you, I'm not, and I'm giving you yet another notice in the same morning. I mean, we just started, it's only 9:17. Okay, this is the second warning I'm giving to you now. But are you going to follow the court's rules of decorum? You didn't answer my question. It's a yes or no.
No wonder he keeps fucking around.
That was my...
Another
I'm going to
rule,
follow them,
answer
but...
questions asked by the court. Answer my question. Will you follow the court's rules of decorum?
I object. I'm going to follow, but I would like you to also
Okay,
follow
that's
your own
all I needed
code of
to hear, that
conduct.
you will follow. And I reminded you, if it wasn't clear, you committed 2 violations this morning. The third one will have you removed. Again, if you are removed, you may provide specific questions to standby counsel, who will then ask those questions. Otherwise, you'll view this trial from Zoom, and that's a decision you make, whether you want to participate or not, and to what extent you participate. That's all. We're going to go off the record until the jury's brought in.
So when he asks, I have some questions, he doesn't have to answer yes or no? He would just go around the question? I can't even ask her. She won't let me ask her anything.
No. Well,
This is a circus.
it's a circus.
Oh, you're right.
It's a shit show. It's a circus.
She shouldn't even be a judge. This is ridiculous.
She shouldn't even be a judge.
Discovery. You can't go through trial without discovery. What is the e-file documents? You haven't given me those. The communications between the state and everything. Where are those? I've requested the transcripts to prove the DA's lie. Committing perjury. Yeah, I know. I requested them in my motions. Why don't we just find out the truth? Hold on. I'm going to be examined by a forensic specialist. Can you send me services? It's material. I tried to do it before trial. No one's doing it to me. You see the two wouldn't open. How can I have it examined if it won't open?
Yes.
Dude, file a Brady motion. Go on, dare ya.
So, Your Honor, may I continue in the same?
You may continue your examination.
Okay,
Right.
okay, I can't handle this anymore. Jesus Christ.
I know. he is special.
I actually find her far more frustrating.
I mean, she's better than Mommy Judge Doro, but
Another day of her, and I think I'd be like, no, she's not.
Yeah, we'll see.
Yeah, she's the same. Yeah, one
We'll
more
see.
day of her. One
We'll
more
see if
day of
she
her. I'm going to put you in timeout.
Well, I
Actually,
think she
no,
starts
no,
to realize that
was-
doesn't work.
I was going to have you on your third timeout, but now I've decided, no, this is your second timeout. Now I'm going to put you on your third one, and your next time that you violate my decorum rules.
Oh, yeah.
Like, seriously, you said you were going to put him in timeout last time. Do it. Fuck's sake.
So what do you have coming up?
A lot of people like Judge Doro. I understand why you would like Judge Doro. However, it was just the way she babied him.
I mean, I don't know.
She had to put everything on the record, and that's Wisconsin rules, right? And so I get it. I get why she had to do that. It just got so frustrating over such a long period of time to have to listen to her speak out everything over and over again, to a point where it felt like, yeah, he was a child and she was reprimanding this child. And like, I don't have anything against her personally. It just got really frustrating to listen to.
Sure.
That's all. Yeah.
Yeah, it got very frustrating.
Very, very frustrating to listen to. So, I mean, and this lady today, it's gotten really frustrating to listen to her reprimand this man over and over again and have to speak it all out onto the record, because it's Wisconsin rules. That's what you have to do.
Yeah.
Yeah. And yes, she was trying to head off any appeals. Of course she was. So it's not a personal thing. It's just, it gets so frustrating to listen to.
Yeah.
Yeah. Oh, I just hate female judges. Yeah.
Yeah, she's a sexist.
Yeah, that's it. I love you, Mobus. You're funny.
What do you have coming up?
Okay, so tomorrow at normal time, 7:15 p.m. Eastern, I will stream again. I shall stream again. So this juror has spoken. The juror has spoken, and I wonder whether more will come out or not. So I'm going to react to people reacting to the juror speaking, because I can't do anything original, and I have a black heart, and I only care about clicks and views, which I don't get that many of, but so I'll do that tomorrow. And yeah, so I'll see you guys normal time for that. What about you? Are you going to go a bit earlier?
Yeah, I'm going to go at 5 Eastern
Cool.
tomorrow. So I'll start a bit earlier and see if we can get up to his testifying.
Sweet.
Hopefully get this done in the next day or two.
Cool.
Okay. I'm going to redirect y'all over to Sean, potentially criminal.
Sweet.
All right, guys. Thanks for being here. And I will see you tomorrow.
Okay.
Godspeed.